Today is November 9th, 2023, and this is the latest installment of MacMull's Musings. Thanks for joining. Today I want to talk about a case involving the right of publicity. A few weeks ago, during one of our prior episodes, we talked about, briefly, the distinction between rights of privacy and rights of publicity. Today I want to talk about a case that just occurred, or just was set down about a month or so ago in the Second Circuit that addresses the issues of rights of publicity, but more importantly, preemption of those rights. Again, let's revisit the right of publicity. What is it? It is essentially anyone's likeness. It can include the voice, the name, the photograph of someone, their signature, or their general likeness, including, for example, gestures and body movements. California was one of the first states to recognize rights of publicity in the late 1970s. There was a very famous case there, and the state, much like other states have since, codified that common law. Of course, California is home to a variety of entertainers, and so you can imagine that there was heavy lobbying going on to recognize rights of publicity. So the case that I want to talk about is one involving John Melendez versus XM Radio. John Melendez, otherwise known as Stuttering John, is a former cast member of The Howard Stern Show. He filed suit suing XM Radio on grounds that their archival footage, I guess they were advertising the program that used his voice, and in doing so, he claimed that that use by XM Radio, by virtue of the fact that he was no longer an employee, was a breach of his right of publicity. Well, the case didn't get very far because the district court dismissed it on grounds that Melendez's claim was exclusively within the purview of the Copyright Act. And the court arrived at that under essentially a preemption analysis. And that's what I want to talk about for just a second. Very generally, and I'm sure I'm not doing justice to my civil procedure professor in law school, but preemption is the following concept. Where there exists a federal law that specifically provides that that federal law will not conflict with state laws, it essentially trumps any state law that provides the same or similar remedy or relief or right. And so that's what happened here. The Copyright Act specifically provides that it and only it grants certain rights. Therefore, if you have state law claims that grant the same or similar rights, they can, as they were in this case, be preempted by the Federal Copyright Act. So on appeal, the Second Circuit made a two-part analysis, and this two-part analysis is common to all preemption issues. The first was it asked itself, is the work at issue, the work that is the subject of plaintiff's claim, is that the subject of the Copyright Act? And in this case, it was. It was something that's fixed in a tangible medium. It was a prior old recording of the Howard Stern Show. So in looking at that, the court made the following analysis. It looked at it and said, wait a second, Melendez is not claiming that his voice is somehow enhanced or that the focus of the advertisement is unduly on him or his voice. And so the court said that's a copyright issue. He wasn't able to hurdle that first prong. The second thing was, or the second prong that it analyzed was, does the plaintiff assert rights that are the equivalent of the exclusive rights provided under the Copyright Act? And the court said yes. Now you need both of these elements to essentially be barred by federal preemption, and unfortunately Melendez satisfied both. But in the second prong, it noted that the remedy and the rights afforded under the Copyright Act were really the same as the rights of publicity under California law. Again, I think I may have mentioned this, the case was brought in New York, but it was brought under California law. And even though the elements of a right of publicity in California include for a commercial purpose, where the Copyright Act does not, they said that didn't matter, that at the end of the day, the remedies sought and the claims being provided were essentially the same, because what Melendez wanted was, he wanted to preclude XM Radio from continuing to reproduce those I guess, vignettes, if you will. And also, in addition to not being able to reproduce them, he wanted to ensure that they weren't rebroadcast. And so the court said at the end of the day, that is a function of copyright law. Now, if you were paying attention, the interesting outcome of this decision is that while Melendez's claim is precluded under the Copyright Act, he has no claim. He's not the claimant. He's not the owner of the advertisement that was at issue. Who's the owner? Well, XM Radio is, or the Howard Stern Show is, whoever owns the program. So this is also, I guess, a little lesson in you can be preempted and not necessarily have the claim or have another claim that you could necessarily assert. So while the right of publicity claim was dismissed, Melendez does not have standing to proceed with a copyright claim. And sometimes, as is the case here, there's not always relief, even though someone might feel that they're wronged. It's one of the lessons we learn as lawyers. So thanks for listening. We'll tune in next week.